Thank you
Well,
everyone for being here. Um, we're going to pick up where we left last session, which is with our review of the draft bill. And at the end of our meeting last time, we were talking about where the notice of appeal when you're in justice court should be filed. And Jim Nass had put a motion on the table for us to decide a motion about where that notice should be filed, whether it should be filed in the justice court as it's currently done under the statute, or whether we should recommend that it be filed in the circuit court, which is the court to which the appeal would be taken. What I propose is we spend a few minutes, if someone wants to speak to the benefits of the current system, which is where it's filed in the justice court, and if someone, same person or someone else, wants to speak to the benefits of having it filed in the circuit court, that'll kind of reorient everyone about this issue. And then if Jim wants to renew the motion, or someone wants to make a motion on that subject, we'll take that up. And just the way that I see it, we are the drafting group, and so we just need to have an idea about what we're putting in the draft. Decisions we will take, our proposals or our draft, and it could have an alternative proposal in it. We will take that to our working group, or our work group on the justice and municipal appeals, and we can still continue to discuss these things. But I think our drafters need some guidance about which way to go on this issue. So with that, does anybody want to talk about where the notice should be filed?
Well, I guess if no one else will, I will speak first in opposition to my motion.
Oh, okay.
At least one of the justices who are a member of this work group described the process in his court, which is that they have the appeal forms there at the counter of the court, and a party who wants to appeal simply fills them out in duplicate and leaves them there. And of course that leaves the original there, and that constitutes filing in the appellate court under current law. And apparently there's a box for service on the other party, or I'm not sure how the service works, but at least I like the ease of filing that the current system affords for those justices. And if we expand this to municipal courts, the ease of filing the notice of appeal. Speaking in favor of my motion, that ease does not necessarily translate into ease of service when the adverse party is a private party. Ease of service does happen when the adverse party is either the DA in a justice court, or the counsel for the city in a municipal court, because the justice court can simply place a copy of the motion in that government entity's box or route it to their office. The other argument in favor of changing the current system is that it makes clear that when jurisdiction shifts from the justice or municipal court to the circuit court, I think it's a little fuzzy under current law when that jurisdictional change happens.
I hate to say that it should stay with justice courts, but I think it should stay with justice courts, because I think otherwise it would be a chilling effect on people's pursuing an appeal. If they're gonna have to go to the circuit court, they're not gonna get the same level, quite frankly, of assistance, is my guess with regard to that. Especially in a small claims proceeding where you only have 10 days, which I hope we all agree to expand at some point when we come to that topic. That should be expanded. But anyway, 10 days, and they have to, post the amount of the judgment with the justice court, either, cashier's check or money order or a bond. And they have to pay the filing fees, which have to be made out to the state of Oregon, not to the justice court. And then the justice court sends that all over. So it's a pain in the rear for the justice court to deal with that. But I think it's much more likely to get done and to get done properly and for the process to go forward. So for that reason, I think it should remain with the justice court. Don't tell my other justices I said that.
I have a question.
Yes.
Justice Cross, the forms that you have in your court are produced by your court and not by operation of statute. Is that right?
That is, I'm not aware of there being any statute that requires it. So if there is, it's not in my brain. And they're produced in this court before I was here.
So my thought is that why would we want to make something applicable statewide just because one justice court, to my knowledge, is so user friendly? I don't think that other justices are as user friendly as your court is, and I think that if you're a lawyer that has done some appeals, isn't this the only one where you filed a notice of appeal in the court you're appealing from?
Well, I believe so.
Yeah, and if you're, I can't imagine somebody would want to appeal from the justice court and pay a seasoned appellate lawyer their high fees to do this, but why would we want to have a outlier statute that is different from other appeals? And why not just make it all of them are the same, file in the court you're appealing to? Because, heaven forbid, some justices don't want to get appealed and are not so friendly as you.
Well, I like to believe I'm never wrong, but I fully entertain the notion that not everybody may agree with me.
Not all justices of the peace are cut of your fine cloth.
Oh,
I'll be quiet now.
wow.
Other thoughts? Anyone else? Well, and I think, yeah, Judge Go.
I don't interrupt, and I will say, because it feels like it's appropriate now, that the reason to have something filed in the court that you're appealing from is because these municipal courts and justice courts are the creatures that they are. They're meant to be there for folks to have matters heard outside of the circuit court system. And I believe they need to be as accessible as possible. And someone who's appealing, who's involved in two of these systems, their ease of entry into the circuit court system is going to be paramount. And if they want to have their day in court, they want to appeal, then they can appeal in the court that they're appealing from, and then make the trip to the circuit court from the city or the justice court area that they're in. Someone said chilling effect. I think that's exactly right.
Mm.
And I also believe that because the justice courts and the municipal courts are the outliers from circuit, that those processes should mirror each other as much as possible. So it doesn't matter what county you're in or what city you're in, your process in Crook County and Multnomah County and Jackson County is going to be the same, and everybody's going to be treated exactly the same. And if the state is going to have creatures like these political subdivisions of cities and have creatures like justice courts, then I think the onus is probably on the state to say, well, our municipal courts and our justice courts will have to bear the burden of making sure that the rest of that process, once it's filed, gets to the circuit court where it needs to go. So without going any deeper into that, I think in terms of an accessibility and trying to make sure due process is as accessible as possible, That's the argument I'm in favor of having it or having it filed in the court that you're appealing from for justice courts and for municipal courts.
And perhaps what we should include is something which requires that the justice and or municipal court provide the information and provide the form to the potential appellant.
Right. I was, oh, sorry, go
Oh,
finish
no,
what you were saying. I was just about to say that, which is just putting in this statute here on section 10 that the justice court shall develop and have available standard notices of appeal for people to use, because that would make it standard everywhere.
Right. I think we may be able to combine our approaches here, which would be, we may be able to say we're going to leave the notice filing in the court where you're litigating, so your justice or municipal court, but we could, to address John Henry's concerns, put things like Jessica suggested in the statute, which could include the notice of appeal. Maybe it even outlines some procedures that the courts are supposed to follow if we think that that would be helpful. And then last time there was an issue about the filing fee and how it, at least in Justice Cross's court, you have to pay the filing fee, and the Justice Court has no authority to waive that fee because it's a fee payable to the circuit court. And the suggestion was made, well, wouldn't it be, maybe it's possible that there could be a waiver application filed in the Justice Court. So you either file your fee or you file a waiver application that's then later ruled on by the circuit court, but that might help people get in the door of the Justice Court while still allowing the circuit court to determine the fee waiver. So it might be possible to keep the accessibility of having the notice in the Justice and Municipal Court, but establish some uniformity and consistent practice and reduce the barrier of the inability to have the fee waiver by the Justice Court.
Let me raise one other point. Under current law, I believe the appellant is responsible for cobbling together what that party believes is the record and filing it with the circuit court. I believe the better practice is to have the municipal or justice court forward the record to the circuit court. So you have an official record that neither party can manipulate.
Mhm.
If that's true, well, actually, let me back and ask: do the justices know about how long after the notice of appeal is filed with the justice court before it's forwarded to the circuit court? Is that just a matter of a day or two, or can that take longer?
In my court, it's a matter of a day or two. I don't know. I can't speak for other courts. But yeah, we would have it through the intercounty document transfer. It would go out probably the next business day. And so it would be there that next business day, typically.
Might not be as easy for municipal courts. They would have to rely on mail. I could support leaving the requirement to file the notice of appeal in the trial court if we imposed a relatively short time limit on that court forwarding the notice of appeal to the circuit court. And I concur with the suggestion that a form be developed so that the form is standard throughout the state. At the risk of incurring the wrath of the judicial department, it has a committee of folks who for years have been developing all kinds of forms. Suggestion that if the task of developing a form is assigned to the justice and municipal courts, that can be done in cooperation with the judicial department, which might be helpful in getting a standard form.
I think that's a good idea, Jim. Uh, Keeping in mind, of course, hopefully the drafters keep in mind that they're drafting a form for non-lawyers. And
They do many of the forms. One of the packets of, actually, they have several packets of forms. One is for dissolution of marriage and child custody and restraining orders, and the other, I believe, is for FED cases. And so they have a lot of experience in drafting forms for self-represented parties.
I think that's a great idea, and having a template of that then in the statute even, which I think Justice Duncan was probably contemplating. I think that's a great idea as well. One thing I'll say about the non-lawyer justices of the peace that I interact with, if it's in that statute and there's an example there, I mean, they tend to follow that. That's a really good concrete tool to implement. And I think that would be something that all justice courts would have. I don't think they have an issue following through with that.
So it sounds like there's a few things that our group might want to identify our position on. The first one is what court should the notice be filed in? The second one, which Jim was talking about, is should there be a time limit for the transfer of the notice of appeal and/or record? That we don't have exact language about that, but I think this group might just address that as a conceptual issue. Do we support that? Third, do we want to have a form notice of appeal for use in these courts? And then fourth, do we want to explore the possibility of drafting language that would enable the Justice or Municipal Court, Justice Court here with our draft right now, to accept a waiver in lieu of full payment? Are there any other issues out of this conversation that we should take up?
Maybe only the fact that in a small claims proceeding, 10 days is way too short a time frame.
Yes, we will definitely get to that. But if we're focusing right now on the notice, is there a motion regarding which court, the Justice or Municipal Court or the Circuit Court, which court the notice should be filed in with respect to what we're going to put in our primary draft? So we did have Jim's motion. Yeah, Jim, do you have a motion?
I will withdraw my pending motion and move that the requirement to file the original notice of appeal with the Justice or Municipal Court be retained, provided that we set it, let's say, a 5 working day limit on forwarding the notice of appeal to the Circuit Court, and that the notice of appeal be accompanied by either the Circuit Court filing fee or a motion to waive or defer the filing fee, and that the Justice and Municipal Courts, in conjunction with the Judicial Department, develop a form that will be made available at the Justice or Municipal Court.
Discussion, and in particular, does anyone want to pull out any part of, break down that motion in any way?
Yeah, I was wondering if Jim could repeat the motion.
No, I can't. Yeah, I think it's has four.
Well, we
parts.
can take them one by one if that's easier, and it might be clearer. Maybe we should, and it might allow for different voting rather than packing them all together. So Jim, on just the issue of what court to file in, would your motion be that it would be, we would retain the current statutory approach of saying you file in the court where you're coming from, your Justice or Municipal Court?
Yes.
Discussion? And vote in favor. So all in favor of Jim's motion.
Do we need a second?
Do we need a second?
I
Let's-
don't know. It's
It's
my
a-
own,
it's a-
it's my own Robert's Rules of Order.
It's a
So-
drafting group. I think we're good as long as the group agrees.
All right.
We can yes, Melissa.
I was just voting aye
Aye, okay.
with my hand.
Okay, thank you. So on the court,
Yeah, I vote in favor.
As I do.
okay. Sandy, are you able to track? So that's, I think we have that vote.
Yeah,
Okay,
I got it.
okay.
Was there anyone, wait, really quick, was there anyone opposed? Okay, that's what I thought.
I
And-
apologize for eating my lunch during this meeting, by the way. I'm sorry.
Okay, no, that's totally fine. The timing, Jim, you had suggested a 5 business day timing for the transfer of the notice of appeal and
Yeah, 'cause I
or
think it's-
record.
I think it's actually 5 judicial days,
5
which can be
judicial
different
days.
from a business day.
That's
Yeah.
true. So we'll say that that is a motion on the floor. Any discussion of that? Is 5 days enough? Do you folks think 5 judicial days?
Well, there's not much that consists of the record. I mean, because we're not courts of record.
Mhm.
So, I mean, essentially it's the judgment. And if there are any pleadings that were filed in the case, which is, not the most common, but I mean, there's not a ton to go into it. So I don't think it would be that much of an issue.
I think it's case dependent in terms of what the content of that case file is going to be, especially if it's going to be a case file that's going to be appealed. It says to me a pretty active case with an active in a municipal court where it's criminal in nature, a very active and involved defendant. So you may have more filings than you need or than you expect. And I think there needs to definitely be a distinction between the notice of appeal being sent to the circuit court in the county that you're in versus the paper record or the record that you have. We have folks who are recording proceedings, and it hasn't happened yet, but a lot of folks are, they're going to have the ability to see if they want that to be the record if the parties in the court agree to it. And if you have that, then you're adding a different layer to that time limit for what the record being passed on to the circuit court might be. So my court administrator might string me up by agreeing to 5 days and not asking for more for the notice of appeal. And we might want to get some input from those folks who are actually in the trenches processing that kind of stuff. But 5 days, that's a week. For just purely the notice, I think that could probably be doable. If more, it wouldn't be a whole lot more, at least for where and it could be done electronically, I'm sure, if a circuit court is able to see that. The record itself, though, whether it be paper or otherwise, I think is a different discussion in terms of how much time that should be allowed.
And you're right, Jessica. I agree with you. I was jumping the gun there. And I didn't think that through fully. Your points are very well taken, I think. And those recordings, some wanky lawyer got pursued that issue to let those recordings happen when in courts that aren't courts of record. It's troublemakers. One might be in this room.
I would like to address what the Right Honorable Nass had to say here. He used a term called judicial days. And I don't like that. Because if I'm a pro se litigant, I don't know what a judicial day or a judicial day is, number one. And number two, just to throw typical lawyer confusion into the seemingly simple, I know of cases that have occurred and the jury trial continued on Saturday. I think one's happening right now in Bend that happened last Saturday. So I don't like the word judicial days. And then you look at the ORCPs and you determine that you exclude holidays and all sorts of confusion because lawyers like to do that. But if it's pro se, why don't you just talk like, Joe Sixpack talks, 5
Mhm.
days? Simple. This other thing, and Judge Gill, I totally know what you're talking about when somebody turns a tape recorder on and then there's an argument that that's going to make it a court of record. Poppycock. It doesn't. The legislature determines whether something is a court of record or not, and a litigant can't. So you don't try to confuse a poor circuit judge into thinking that it's a trial de novo or whether it's on the record and whether you can add additional. You don't do that. It's just that doesn't make it a court of record. And I don't think that's really germane to the main issue, which the Right Honorable Nats says, make it 5 days. That's what I would ask you to friendly amend your request as to the time for us to vote. That's
And we-
semi Robert's Rules of Order, and I'll be quiet.
And we can break the motion. It is possible we could just break the motion down to say we want to put the responsibility on the court to forward the notice. We can make that a statutory requirement and then separately address the time for doing that. I don't know. Jim,
If I could speak to use of the word judicial day, since this is a statutory duty imposed upon court personnel, I don't think we have to worry about whether pro se people will understand the nuances of a judicial day, but certainly court staff understand the significance of a judicial day. If the Chief Justice has closed the courts because of weather, that's not a judicial day, that would be excluded. Columbus Day creates confusion as to whether that's a business day or not. So I would be comfortable sticking, in fact, I would not be comfortable, I'm in favor of using the word judicial day, because that is a word of art that takes into account all the things that can result in closure of a court on what would otherwise be a business day on a Monday through Friday. And because it's a term of art that I think can be talked to and understood by court staff.
I would like to take issue with that. If you're talking about a justice of the peace in Wallowa County, I don't even know whether they have a justice court, that person doesn't necessarily have to be a lawyer. And the court staff could be people that don't have a GED. And I think it's assuming too much. And if we want to try to keep it as simple as possible, I don't like that adjective, judicial. I'll be quiet, honest this time.
okay. So, yeah, I see. Yes, Justice Cross.
Well, I don't have horribly strong feelings either way on judicial or not. I think both points are well taken. If we go with non-judicial language, then I think we should maybe account for that with rather than 5 days, make it 10 or something like that, just to create a broader spectrum to cover the types of things which I think Jim is quite legitimately concerned about.
And Jim, at this point, could you clarify whether, like, I think in response to Judge Gill's point, is the motion, I'll have you restate the motion and in particular, whether or not we're just talking about the notice at this point, notice of appeal, and we will be taking up record issues and transfer of record issues and timing issues later.
Yes, I'd
those.
like to separate. I would like to keep those. I'd like to keep those separate, and I would like to keep the time frame relatively short, because remember, the filing of the notice of appeal results in a change of jurisdiction to rule on the case, and that during the period of time that the notice of appeal is left with the justice or municipal court. And the day that it arrives at the circuit court, the case really is in limbo land and no one really, I mean, in theory, the justice court, the circuit court has jurisdiction of the case because the notice of appeal has been filed. But in fact, it can't rule on anything because it doesn't have anything. It doesn't have notice of appeal. It knows nothing about the case. So that's why I would like to have a relatively short period of time. And I think the Justice of the Peace Association and the Municipal Judges Association can certainly educate their judges and consequently their staff on what a term like judicial day means.
So Jim, do you just want to state the motion and then we can vote on the motion?
Yes, my motion would be that the justice or municipal court with whom a notice of appeal is filed would be obligated to forward the notice of appeal along with okay, I'll just limit it for the notice of appeal within 5 judicial days after filing.
All right.
I would move to amend the motion and make it 10 days.
Okay.
Justice Cross, are you using 10 judicial days or just 10 days?
10 days. That's why if we're going to use Jim's, well, I shouldn't say it. I'm not sure what. I just think 10 days. I think 10 days. I like the idea of just making it not too hyper technical, and 10 days then covers it. I think just 10 days.
We usually say 10 calendar days, just putting that out there. Hopefully people don't think that's a confusing term, but that's when we're just talking counting days on a calendar. That's what we use.
Is the current language just 30 days? I think that's what it is, right?
I think it's the notice needs to be filed within 30 days, and I don't think there's a current time limit at all for the transfer of the notice from the justice court to the circuit court. So we would be creating a time limit.
Yeah, it's 3 days for everything except a small claim.
I would like to raise a rule of order.
Yeah,
I think honestly that Robert's Rules of Order has value.
Yeah, okay.
And technically, well, not technically, Jim Nass doesn't have to accept that motion.
That's true.
And
Sure.
I think that for the efficiency of this group, we ought to try a little harder to beg, just what I'm going to call the person who wrote it, very just Roberts, who wrote Rules of Order. So I just say that we ought to stop this discussion because did somebody second Jim's motion?
No, we haven't had a second, and I'm happy.
Judge Cross just jumped in and moved to amend it. So technically, it's not before us to even discuss, because after somebody seconds it, that's when you have discussion. I know all this because I have to do this at church, and doing this with lay people, it makes them want to vomit. But,
Okay.
I think we ought to try the best we can to obey old Roberts.
Okay. I don't have any problem with that and would welcome your jumping into and saying and Sandy as well. We can use Robert's rules.
That's fine.
And so we've got a motion from Jim. So John, we need a second. Is that correct? I'm not calling on you to give a second. I'm calling on you to confirm that we need a second. Is there a second for Jim's motion? Okay. Not seeing a second for that. Is there
Old Roberts would say it dies for lack of a second.
That
Okay.
is true.
Okay.
he knows this. I'm gonna shut up and let him handle it. I'll be
All
quiet.
right.
No, you're
I'm
good, John.
gonna keep talking. I'm sorry.
Is there another motion about the subject of having the Justice Court forward the notice of appeal to the Circuit Court?
I don't think this is
No one else-
correct, but I'm going to make a motion to talk more about the time calculation piece.
Okay.
I don't think that's proper, but I think that's a more discussion could inform the next real motion to actually get something accomplished and get
Yeah.
a second out of it.
Justice Duncan, I think that if we're running this as a formal meeting, you're as the chair, I think you can call on whoever you like to forward the discussion in whatever manner that you choose. Because there is no current motion on the table.
Right, we don't have a motion. Judge Gill's asking for additional discussion on the timing piece for the notice.
I will make a motion that the Justice Court be required to forward the notice of appeal within 10 calendar days of the date of filing.
I'll second that.
Now there's an opportunity for discussion on that motion, correct?
That is correct.
I was going to agree with what Justice Cross for the same reasons. Just sort of give a broader time period. That way we don't have to get into the nitty gritty of the judicial or business days.
Further discussion?
I'll call the question.
Second the call.
And vote, right? John Henry, that's,
Yep.
we're voting. All
Correct.
right, voting on 10 calendar days. 1, 2, 3, 4. Okay, I see 4, 5, I see 5. Okay. So that motion passes. Okay.
I assume there were
John?
those, what were there? I assume there were some opposed, just for the record.
I don't think that we should assume that. Some people may be abstaining.
There may be abstentions. That's
Technically,
true.
the
So
thing is, all those
all
opposed,
those opposed. Yeah.
I'm very embarrassed about telling somebody about Robert's Rules of Orders, particularly a justice on the Supreme Court. A justice.
Please do not be
Oh,
embarrassed.
don't be.
and-
No, John, every one of these groups kind of has their own way of running things, but this is totally fine. I think it makes sense. So any abstentions to the last motion?
Well, I-
Legislative, oh yeah, I was just gonna say legislative council, I didn't mean to interrupt you, Justice
Go
Duncan.
ahead.
We don't take policy positions, so obviously we're not voting. We're not voting
Understood.
members of this
Right.
group. So just making sure everyone understood that.
Yeah.
And I would just abstain on this because I think it's a policy decision that the people that are doing it should make.
Can I just ask a question?
Yeah.
Is anything in saying 10 calendar days going to be run afoul of ORCP 10? It's been a while since I've used ORCP 10, but it kind of tells you how to calculate time, how time will be calculated for the rules of civil procedure. And since we're dealing with both civil and criminal time calculations, I don't know if 10 calendar days runs afoul of that or not. I'm on a single screen, so I can't look at it really quickly, but I do remember there's some nuances to that might affect the calculation of 10 days. There, if I remember correctly, there was, if it's 7 days or less, it's calculated one way. If it's more than that, you don't calculate Saturdays and Sundays, holidays and that kind of stuff, but I don't remember specifically. And I just wanted to bring up because I was thinking about it. Does anybody remember what that is? I could look at it really quickly. Actually, not really quickly, but I guess here's the real question. Is there anything in
I have a point of order.
RCP that would affect what we're doing right now?
I have a point of order. I see
Yes.
the clock going around. Just keep going. This is out of order. We're calling for a vote, and you're talking about discussion. Time has passed.
Okay,
I'll apologize, Your Honors.
As far as the 10 calendar days, so we can, I think, Jessica was saying that that is a term that they do use, Legislative Council uses, and we will check that against ORCP 10. And we can, in the draft, annotate that to explain how that would work together.
Right, and
Yeah,
I think,
I think as a technical matter, the ORCP do not apply to the justice or municipal courts.
The-
Unless
the
they
what-
choose to, unless a court chooses to adopt them, they only apply to circuit courts, I believe.
I was just gonna say that the time calculation would be governed by ORS 174-120, and that has the way of counting days. And that would apply even if we didn't use the term calendar. I don't have to use the term calendar if people are uncomfortable with that, but I guess I've started to use it in my drafting to differentiate between business days, calendar days, judicial days.
I beg your pardon, but I know that there are, for instance, administrative rules that say in computing time, you follow the technique set out in the ORCPs. But speaking to the applicability of the ORCPs to justice and municipal courts, I think Jim Nass hit it on the head. They don't, by their own terms. So if an individual court wants to apply them or not, that's possible or not. I don't know whether they have authority to do that, but that's beside the point of what we're doing today. So I don't think they necessarily that they apply unless they say they apply, and they don't, to my memory, to justice and municipal courts. But I think we've disposed of the motion. Maybe I'm wrong. I think that it passed.
Mhm. Yes. The other issues that we talked about in connection with the notice, which I think the group, there was some consensus around, was that it would be helpful to have a form, and Jim has one in the small claims section that we have materials on. Is there, and I don't know, is there interest in pursuing having a form? And I don't know if we need to call for a motion on this, but it seemed like there was consensus around having a form notice of appeal. Is that the sense of the group? Okay.
Yeah.
I'll read. I'm going to go a little informally here. It's not really a policy decision, so we can have a form. And the other thing that we had talked about, which would be in addition to the draft, would be whether or not we would explore the possibility of providing for a waiver, providing for the opportunity for a litigant to submit a waiver request in the Justice Court, waiver of filing fee request. Thoughts on that?
Well, I think the court should, and providing it is a good idea. I'm just the reason I've already said earlier. I won't keep doing that too much. It's just the folks, that assistance helps those folks.
well, if that sounds like something that we should, it sounds like that's something that we should explore adding to the draft. Jim, any?
Yes.
Yes, okay. Okay. Those are the issues that I had left over on the notice of appeal form subject. And then we
I'm sorry.
have,
I'm sorry to raise one more. Whenever a statute imposes a time limit, invariably a litigant will argue that if there's a failure to comply with the time limit, that somehow it's jurisdictional or fatal to the appeal. And I think the statute should make clear that it is not, that it's and I'm not sure how I would draft it, but the concept is that it's an administrative task and there's a time limit for getting that task done, but it has no effect on the disposition of the appeal if the notice of appeal doesn't arrive at the circuit court until the 11th or 12th day.
that makes sense, and it's consistent with some of what's in the draft as far as an error made perhaps by the litigant in service or filing in the wrong court. Your draft says that those things aren't jurisdictional. This would be similar.
Yeah, I mean, it's even possible that if the municipal court has to rely upon the US mail, that the letter ends up in the dead letter file in San Francisco, and the circuit court never gets it.
Does anyone have any thoughts on that? Allowing Jim to put something like that in with the timeline. Mhm.
Sorry for talking so much, but what happens if a person files a notice of appeal 3 years after judgment? Is that non-jurisdictional? I don't think from a standpoint of efficiency that ought to be the law.
No,
There's a-
not the notice, the timing for the filing of the notice of appeal would be jurisdictional. There's not any exceptions for the deadline for the filer. This would be for the transfer, right, Jim? That's what you're talking
Yes.
about, the transfer.
Okay, well, I thought you were talking about notice of, you used the term notice of appeal.
Yeah,
You're just talking about the transfer of the
of the notice,
file
yeah.
to the court having jurisdiction to hear the appeal. With that understanding, I'll be quiet.
Okay, okay.
Don't do it.
Okay. Okay, we may be at a good breaking point. We're not to the end of the hour. Our next subject of discussion is the small claims materials that Jim has prepared. And I think that that would take more than 10 minutes to get through. So my recommendation would be that we have Jim give us just things to think about on that subject to keep in mind before our next meeting.
The only thoughts I had were that I believe that the notice of appeal process should be as much the same as the process we've already described here. And I think part of what's a little uncertain under current law is whether and to what extent it is the same. So I think we need to make clear which things are the same and which things are different. And by all means, let's change it from 10 to 30 days. I mean, that 10-day limit is just does not work.
Okay. And I would make also a suggestion that when you look at Jim's draft, you'll see that there's a dollar figure for attorney fees, and then maybe also another dollar figure for, I don't know if it's filing or something. Yes, it's a fee for entering the judgment. My recommendation will be that as we're going through this drafting process, we leave all the dollar amounts as they are. And then once we have our draft, we can do a single review to make sure that we are figuring out the appropriate recommendations with respect to the individual dollar amount. So don't worry too much about the dollar amounts in the draft. We'll revisit all the dollar amounts before we at once so that they're consistent. And so we have that discussion one time. All right. Krista, anything else that we should cover today?
I don't think so.
Okay.
And we have a
Sandy?
meeting. Yep. Oh, I'm
I
sorry.
was
We
just
have-
going to say,
Yeah, next meeting should be on your calendars. It's scheduled for December 9th at 1 o'clock. I know that not everyone could come, but the majority could. If you want, I could start scheduling meetings after the holidays just to make sure we keep on track. But the December one is the last one we currently have scheduled.
Sandy, can you send out a doodle poll for at least January and February?
Absolutely. Yeah.
Okay. And I know Jessica and Victor, you'll be busy with the legislative session, so maybe we should also do March if we can, because we might want to grab time on your calendars while it's still available, with the understanding that in the session, you might not be able to make, both of you might not be able to make all of our meetings. If there is a particular day during the session where you're more likely to be available, please do let Sandy know.
Yeah, just for both of you, especially, yeah, Jessica, let me know, Victor, you as well. And I'll base the scheduling off your schedules because I know how crazy that gets. Okay.
Okay. Well, thank you, everyone. I appreciate your time today and your thoughts on these issues.
Sounds good.
All right. Thank you.